in the matter of the
Good morning, my ladies and my lord. I'm Mr. Fasley. I appear on behalf of the appellant mother. My learned friend, Mr. Jarman KC, appears for the respondent father. May I just check that you have the core bundle in this appeal before you?
I'm slightly confused. I have you, Mr. Fasley.
Yeah.
Is that the right way to pronounce
Yes.
it? Thank you. I don't want to get that wrong. And Mr. Jarman. Yeah. This gentleman here is...
he's a solicitor, my lady, assisting me in this appeal.
That's fine.
And Mr. Sadian.
Thank you very much indeed. If you and thank you, because your name also appears in relation to the documentation that we received, for which we're extremely grateful. So thank you for the extra work that you have done, both of you. Thank you. I also, so please do take a seat. Thank you. Before you go any further, I would like to thank Ms. Nuttall, who has done an enormous amount of work here to make sure that we have the bundles and that we have the bundle that was below as well. Yeah. And I'm very grateful to her.
She's not here, but those comments will be passed on. Of more concern is that the mother's not on the link, as I understand it. Oh. I don't know how she's attending this hearing. I don't know. I'm not aware, and I haven't been told. But I know that she remains in Bolton, and that she was going to join the link remotely.
Do we know about that, Mr. Fasley?
Yes, that's my understanding, my lady, that she will be joining remotely in watching the live hearing proceedings.
And so you've not got any concern about the link and whether it's effective?
No, my lady, no concerns.
Thank you. Thank you for that. Okay, could I also say that we've received, and I expect you're going to mention the fact that we have received just before this hearing a witness statement from Miss Dixon.
Yes.
Are you going to say something about that?
Yes, my lady, there are two preliminary issues. One is about the amendment to the late grants of appeal. My friend and I had a discussion, very kindly agreed that he would remain neutral as to whether or not the court permits the amended grants to proceed. And if you want me to address you on that, my lady, I'll be happy to do so.
We're happy.
We are happy that you should proceed on the basis of the amended grants.
Thank you, my lady. Very grateful. My lady, the next issue is the application to adduce the witness statement from Miss Dixon that was filed yesterday evening. There is an authority that a copy of which is provided to my lady, and that is the case of Dr. Latif against the General Medical Council, 2022, England and Wales High Court 2743.
Have we got that?
I have it for the first time here on the bench behind Miss Dixon's witness statement.
Okay. Oh, right.
Thank you. It's paragraph 16, my lord. Anyway, that was a judgment of Mr. Justice Fordham, in which I appeared for the appellant. And in that case, the appellant's witness in the appeal of the tribunal below, who had given evidence, unlike this appellant, who was merely assisting the mother, and he then sought to adduce a witness statement in which he set out the procedural defects that he experienced because, for example, of the online forum through which he gave evidence. And Mr. Justice Fordham agreed in paragraph 16 that the evidence about what happens at the hearing cannot fall foul of any fresh evidence requirement. Agree effectively that the Landon-Marshall criteria doesn't apply to evidence that arises from matters arising in the course of a hearing. And he also agreed that he would be open to the court to admit only that part of the evidence which describes what happened at the hearing. And really he set out that the test is whether or not it's in the interest of justice to adduce that evidence. Alternatively, also whether or not the GMC against Adigoba criteria test is met, which in essence he sets out in paragraph 16 is the ability to influence the outcome, any apparent credibility in the evidence. And in my submission, both tests are met. It is in the interest of justice to admit the evidence because they go to the core of the grounds. One issue in terms of procedural defects is the issue of the appellant's symptoms that she displayed in the course of the hearing, which demonstrated that she was particularly vulnerable, and which we say wasn't sufficiently factored in to the assessment. The other point that Ms. Dixon makes in her statement is the evidence about how she was effectively limited in her ability to ask questions of the father, and how she had a short period of time in which to cross-examine, how she, the appellant, wasn't able to cross-examine or put questions rather to Ms. Hamadi, the expert, because of a lack of payment, and how the father's behaviour at the hearing had intimidated the mother, and therefore suggesting that denied her a fair opportunity for a hearing. And there are other reasons.
I'm a bit puzzled by this business of a lack of payment. Mackenzie friends don't normally get paid.
Lady, I hesitate to rise, but it's probably not within my William friend's knowledge.
Yeah.
It was the Mackenzie friends, a professional Mackenzie friend, Miss Dixon, and for your information, she sits at the back of court. She had, or the mother had instructed her on the Monday before the Wednesday hearing.
Right.
And she had asked for a fee which the mother had paid. It was then adjourned from the 9th of August to the 31st of August for what was to be a one-day hearing, but in fact turned out to be a two-day hearing. And for the preparation of that hearing and to represent, or in fact not to represent, but to attend with the mother, it was agreed that a further fee would be payable. In total, for the second part of the final hearing at the end of August, Miss Dixon wanted £1,800, which was discharged by the father shortly before that hearing.
For the total amount?
The total amount after the 9th of August. So the total amount, I think the daily rate was £450.
So and your client paid that?
My client paid that for the final hearing at the end of August.
So the total amount he paid was?
Total amount was just over £2,000.
Thank you.
Well, I'm well aware that this isn't my sort of field of practice, but I'm a little surprised to find that professional Mackenzie friends are instructed in cases such as this. The normal pattern of a Mackenzie friend is that a Mackenzie friend is somebody who's there to just help and assist, and not to act as an advocate, obviously.
Indeed.
And normally, if the court, certainly in my experience, if the court were going to allow a Mackenzie friend to address the court, one of the first things you ask is, are you doing this professionally? Are you being paid for it? Because it's potentially a breach of the Courts and Legal Services Act if a non-qualified person addresses the court or acts as an advocate.
It was made clear by not only by Miss Dixon but also by the mother that Miss Dixon was not qualified. She was not legally qualified. There were a number of prepared questions for the CAFCAS officer which the mother had prepared, and it was simply on the basis that the Mackenzie friend would ask those questions effectively to Miss Ashton, who was giving evidence at that particular part of the trial. It was known to the courts and known to the father that she was being paid for that purpose. It wasn't on the basis that she was representing the mother, that she was assisting the mother as a Mackenzie friend, but at the time of the hearing, the mother indicated that she did not wish to ask the question. She wished Miss Dixon to do that. The judge was very clear, and I have an attendance note, and part of the difficulty is I had this statement late last night, so we haven't had time to obviously respond to it, but the notes of the hearing indicate that Miss Dixon was specifically asked by the judge whether she was prepared to do that role, and she answered in the affirmative.
Right,
so that was the basis on which Miss Dixon then not represented but asked questions, put questions to Miss Ashton, and subsequently to the father when further limited evidence was deemed by the court to be necessary.
Thank you very much for your assistance.
Thank you. But the other point in the statement is the Ms. Dixon's evidence about the English language difficulties of the mother and the issue of interpreter. And for those reasons, I respectfully submit that the evidence is, on the whole, apparently credible, and that it is likely to influence the outcome of the appeal on the whole. In the alternative, that is in the interest of justice to admit that witness statement. Those are my submission, my lady, on that point.
Thank you very much. Mr. Jarman, do you oppose this?
I understand you've been sent the statement and therefore have read it. And in those circumstances, I can simply comment on the statement itself. We, of course, had it late last night. It wasn't anticipated in advance, and I accept my little friend very late in the day come on board in this case. And we're very grateful for him taking on what effectively was an appeal with 1 day's working notice. The difficulty I have is that there are elements of that statement we don't agree with. And in particular, we don't agree in relation to evidence of PTSD, which we say was not put before the court. There was no medical evidence or therapist letters which were referred to in that statement. Paragraph 10 in relation to the intimidating behaviour was not raised with the judge. If it happened, it wasn't made clear. I wasn't made aware of it, neither was the judge at that hearing, and the matter proceeded in any event. It was a Teams meeting where both parties were on a screen at their respective homes, so they would have been able to see each other in that context. But Miss Dixon was sitting with the mother in her own home at the time, and of course it gives some context to what happened. But essentially, as I've indicated, Miss Dixon was prepared to ask questions on behalf of the mother which had been asked, and effectively at the end of the hearing make submissions on her behalf. It wasn't a role that was forced upon her. It was a role that she accepted to do. She's a professional Mackenzie friend, as she makes clear, and that was the situation. The judge dealt with those preliminary issues at the beginning of his judgment, and I'll come on to deal with those in due course. But lady, I'm not in a position to formally object. You've read the statement, you see the context. I simply make those comments that we've been unable to reply with any meaningful time as to some of the comments that are made by Ms Dixon.
Thank you very much, Mr. Jarman. I think we will approach that evidence in the light of your submissions, but also de bene esse. Thank you.
Thank you, my lady. Very grateful. Lady, the facts are this matter are helpfully summarised in the chronology, which appears at page 34 of the matter. With your permission, my lady, I'd like to move on to the first of my grounds of challenge. And that appears at paragraph 6 of the skeleton argument. And the complaint is that there were a number of procedural irregularities, which, in my submission, cumulatively affected materially the appellant's ability to give the best of her evidence and to fully participate in the proceedings, bearing in mind this was a finely balanced case. I made clear from the outset, my lords and my lady, that I don't see to suggest that on their own any of those alleged irregularities are sufficient to render the decision unsafe, but I say cumulatively, on the whole, they are material as to the outcome. The first point is the point about the appellant's PTSD. The mother says that she was diagnosed with PTSD about 3 weeks prior to the fact-finding hearing, in light of the abuse that she experienced, much of which was found credible by the court below. And I'll take you to those passages later in the second round of challenge. The mother also said that she displayed visible signs of distress and anxiety. That is also something that's been supported by Ms Dixon in her witness statement. And she said that she struggled to remember, for example, page numbers. And that the point there being that not enough allowances were made in the decision and in the way the hearing was conducted to take into account those conditions. Now, the evidence for the PTSD is the bit that the court would want to hear about. My lords and my lady, in her position statement, page 373 of the core bundle.
Now remember, we haven't got the core bundle. Just to remind you what happened on this, we declined. May I say this? We declined the invitation to file the whole of the bundle as a supplemental bundle, that being contrary to the rules of this court. So we haven't.
We've got copies.
I don't think
it's
this is
the
the trial
core.
bundle.
Yeah.
I think this is the
Core appeal bundle.
The appeal bundle.
Yes.
Forgive me.
I'm so sorry.
My mistake. Entirely my mistake.
But I have to say also that I do have.
You've got it.
We've got 3 copies, my lady.
Yeah.
Yes, yes.
I think they've been handed up to you.
Have you got 3 copies of the supplemental bundle?
Have you got?
Of the trial bundle?
You don't seem to have it. I have it here. 1,000 pages.
Yeah.
What happened? When
That's your pages. This is.
I think we contacted the courts to see whether you wanted the trial bundle, and we were firmly told that you didn't want a copy of it.
that was the firm view of the Constitution, but we have asked that a copy of the trial bundle be available if required. Anyway, it's my fault.
No, no, at all, my lord.
We're in the appeal bundle.
Yes, my lord. Grateful. I'll rephrase that, my lord.
It's not your fault. It's my fault. what page number?
373, my lord. And paragraph 5.
Yes. Mother's position statement.
Yeah, so this was a position statement that was dated the 8th of August, right at the top, 2023. This would have been before the judge at the final hearing, and she talks about diagnosis of PTSD, and the nature of the condition is that I can't think. This condition means I cannot think clearly in times of stress. And similarly, my lords, at page 412 of the appeal bundle, paragraph 49, again sits out that I am suffering incredible levels of stress and trauma-related PTSD, which affects my ability to respond and think clearly. I have not been able to maintain representation, have debts I cannot pay. Those are the references that I could find in the evidence. The appellant has also informed me that she had a letter from her GP and some therapist documents, which made reference to PTSD, which was submitted. Now, I looked through the trial bundle on 3 occasions, and I wasn't able to find any such letter. Ms. Dixon informs me that she had also seen evidence that she believes was before the court, which suggested that the appellant had PTSD. Now, at that point, the point that I make is that even if there wasn't evidence before the court,
if your lordships may, there's
yes, but I think there is evidence we've been sent now about her PTSD, but it's probably too late in the day. But that's what we've been sent now by the appellant, which comments on her PTSD from her GP.
And that you've just received by email.
We've just received by email, yeah.
yes, your lady.
Yes. Just. Sorry.
Why was it that?
No, we've only just received this.
Forwarded to all, yeah. And Malini, the wider point I wish to make that even if there was no evidence before the court in the form of medical evidence establishing that, the submission is that the judge was under a duty to make an inquiry, given the contents of the position statement, to at least comment on what was stated orally, and then assess whether or not any weight can be given to that. But it appears from the judgment, my reading of judgment, that there's no mention or reference to the appellant's PTSD. And that is particularly so because we know from Ms. Dixon, but also from the appellant's original grounds of challenge, that she says she was very anxious and that she was under stress, and that she struggled very much in the course of the hearing at the court below.
What more do you submit that the judge should have done that he didn't do to accommodate that stress?
My lady, one of the issues raised by the appellant is that the father was also present at the hearing remotely, which was visible, and that he did that intimidated her, and also that he used language, which is what Ms. Dixon says in her statement, that was inappropriate, that caused her further discomfort, and made her made it very difficult for her to participate effectively in the proceedings.
So what should the judge have done about it?
So, sorry, my lady.
So what should the judge have done about it to make the proceedings fairer for her, do you say? I mean, he couldn't shut the father off the screen, because he's got as much right to participate in these proceedings as the mother does.
Yes, my lady. My lady.
He's not going to be able to gag the father if the father wants to say something or he's invited to say something.
Yes, my lady, he could, for example, have said to the father that when the mother was giving evidence that he could turn off the camera while remaining in the hearing, or to make sure that the father is warned prior to the hearing not to speak or to say anything that would cause discomfort to the mother in light of the findings made at the fact-finding hearing. We know, my lady, from Practice Direction 1A, which I'll take you to in a later amendment, that the court is under a duty to make the necessary and relevant allowances for vulnerable witnesses. While I'm at that point, my lady, I'd just like to take my lords and my lady to the authorities bundle, the appellant's authorities bundle, and specifically page 39. Sorry, page 15.
Sadly not numbered.
No.
Sorry, Mademoiselle, that's the numbering on the... Oh, you've got imprinted versions, so sorry, yes.
What case do you want to cite?
It is a case of brackets vulnerable party, fairness of proceedings.
So that's all. I recognise this case.
Yes, as my lord's case, yes.
Yeah. All right.
And it's the first one, I think, in this bundle.
It is, yes.
What paragraph number in
it is, the paragraph is paragraph 38. I realise I have the electronic version, which isn't numbered. My lord, the paragraph 38.
Yes, I think we've got that.
Thank you, my lord. And that was the case in the context of an appeal in underlying care proceedings. And the court observed in that case, my lord observed, that the court's duty to identify any party or witness who is a vulnerable person arises not only under the express provisions in Part 3A of the Family Procedure Rules, but also under the overriding objective provisions in Part 1. And then it goes on to observe the duty is to identify such person at the earliest possible stage, an obligation reinforced in proceedings under Part 5 of the Children Act. And paragraph 39 then goes to make observations about the duty being firstly on the representatives and parties of proceeding to make it clear to the court whether or not they have any vulnerabilities to which the court should be aware. And it observed that we consider that good practice requires the party's representative actively to address the question of whether a party is vulnerable at the outset of care proceedings. And so the submission I'd like to make on those two paragraphs is that the court has an overriding duty that when it witnesses vulnerability, and my submission was more apparent in this case because of the finding of facts the court made in respect of the abuse that it said was endured by the mother, they would have been well placed, and certainly what was said in the position statements, to inquire what evidence do you have, mother, about these the assertions that you make as to PTSD invulnerability. And of course, when the Mackenzie friend spoke on her behalf at the hearing, the court, looking at all the circumstances, ought to have made an inquiry to ascertain whether or not the mother required any assistance, whether or not she was vulnerable by reasons of her mental health conditions, specifically when they were expressly mentioned in the position statements. In one final paragraph in my Lord's judgment in this case, paragraph 44.
44?
44, ma'am.
Thank you.
My Lord observed in that judgment that we've reached a clear conclusion that the failure in this case to identify the appellant's cognitive difficulties and to make appropriate participation direction to ensure that the quality of her evidence was not diminished as a result of her vulnerability amounted to a serious procedural irregularity. The outcome of the hearing was unjust. And then it talks about the complexity of the hearing being over 9 days and making the position, the assessment of the demeanour and competence of the witness in less than optimal conditions via video link. And so the submission I make is that in this case we say, my lord and my lady, that the court was made aware that there was a diagnosis for PTSD, even if this court were to find there was no evidence of it before the court below. And given that that was the case, that the failure to notice and investigate those conditions in marital submissions amounted to a procedural irregularity, which meant that the court did not treat the appellant as a vulnerable individual to the extent required. And we know that vulnerability, my ladies and my lord, is relevant to the assessment of credibility itself, and that it can be a factor. There is a tried authority for that, my lady, and it's not in dispute that that is the case. The second strand of the complaint in the ground one is the issue of the child's, one child's special needs and the application to adduce further evidence, paragraph 9 of my skeleton argument. In her statement for the final hearing, the mother's position was, my lord, my lady, page 211 of the appeal bundle, that, and I quote, this is the fourth line on that page, that the child is receiving lots of support from the school. She has cognitive learning difficulties. She was evaluated by school nurse and thinks the child may have mental development delay. The school referred her to see a pediatric doctor in the near future. Moving on to the paragraph that begins, the children continue attending school in St. Teresa, and in the third line, the mother will make the children available to the father whenever he comes to visit the UK. And yes, I think that's the only paragraph. Apologies, my idea. Referring to the learning, perceived learning difficulties, and equally the letter on page 382 of the appeal bundle is a letter from Lindsay Hartman, who's a professional teacher in the UAE. I think this was evidence that wasn't adduced by the court below.
Sorry?
Yeah.
Again?
I think this was evidence that wasn't adduced and the trial below. The judge did not permit this evidence.
So,
Yes.
on what basis are you referring to it now?
Page 382.
No, on what? Sorry. You say the judge didn't permit it?
Yes.
Right.
Yeah. And the point that I'm going to make later on, my lord, is that that was it was an error not to do so, given that it's relevant to the education needs of the child and the overall inquiry.
I'm just trying to think of the right
Yes.
order. So first of all, you need to you invite us to consider evidence which was not before the judge.
Okay, my lord. The reason I took my lord to that letter is to set out the background as to what the position is in the UAE. Not so much about admitting that evidence, but more about what it's like for children with learning difficulties in the UAE in terms of the education facilities that are available.
Well, forgive me. Was this evidence before the judge?
It was in the. I understand it was in the bundle below, but it wasn't admitted, is my understanding.
All right.
So that I can understand.
Yes.
Therefore, the judge expressly refused to consider it. Is that right? No. I wonder whether Mr. Jarman can help us with this.
Yes,
So no, this is the mother's evidence that she sought to adduce, and I think it's dealt with in my skeleton arguments at page
oh yes.
paragraph 108, and in particular within the judgment at paragraph 57.
Sorry,
Page 57 of the judgment. Further oral evidence, an application to file further evidence by the mother's dealt at paragraph 24 of the judgment, page 57 of the bundle.
I apologise. Page of the bundle.
Page of the bundle 57,
Thank you.
paragraph 24.
And where, so you gave an extempore judgment about this at the time, as the end of paragraph 24, and then he expands upon it further on in this
Yes,
judgment.
at page 70, paragraph 41 onwards.
'41. Is it a ground of appeal, Mr. Parsley, that the judge was wrong to refuse to admit this statement? Have you said that in any? Was that in the original grounds, or is it in
there
this
wasn't.
ground?
It is in the renewed grounds. It renews an argument, my lord. The judge refused to admit two things. One was that letter, but the other one was the assessment of the child from an occupational therapist in November 2023.
Right. So, as part of your procedural irregularity ground,
Yes.
you're contending
Yes.
that the judge was wrong to refuse to admit Ms. Hartman's document.
Yes, my lord, and also the evidence from the occupational therapist that the assessment will be done, or likely to be done, in November 2023. And paragraph is page 54 of the.
Where do you say in your skeleton argument assert that the judge was wrong to refuse to admit this document? I may have missed it, Mr. Fuzzy.
Yeah.
Forgive me if I have.
They're all, my lord.
I'm looking at paragraph 10.
I think what I've done, my lord, is on the subheading above paragraph 9, I've just put in application to deduce further evidence, without expressly saying that was challenged. But what I meant was that the two things that were not admitted, the instruction to adduce yes, I think sorry, my lord, paragraph 11.
You go in the third line of paragraph 11, you say the court below failed to appreciate that it was not proportionate given the evidence in existence as to the learning difficulties to have proceeded with the final welfare hearing.
Yes, well, the suggestion was that the court should have allowed, adjourned the hearing to allow for this occupational therapist to conduct a report on the child, and also to admit that letter in relation to the position in UAE for the provision of services. I just take my lords and my lady to the court's decision to set out the evidence that was in existence as to the conditions of the child, and that is that the court accepted, this is page 70 of the appeal bundle, paragraph 42, that the Kafkas has observed that the child is of low ability and may have some form of development delay, regularly engaged with school, listening services. And in paragraph 43, the court observed that she receives help with her reading in school. So that's 44. And at paragraph 45, the court observed that the school has made a referral to a pediatric assessment. And at paragraph 46, that the mother is concerned that the child may have autistic traits. At 48, that the child has also been referred to a speech and language therapist. And having set out this background evidence, the court then observed at 49 to 50 of its judgment, there is a concern, there is no diagnosis of a development delay, and that to adjourn the hearing for some months is not attractive. He went on to find at paragraph 149 of his judgment, that because this issue was dealt with sort of throughout, in a sense.
But the judge's approach was that he accepted that there were concerns about possible developmental delay. That was clear from the Kafkas officer's initial report, I think.
Yes.
And declined a suggestion that there should be a further investigation of this issue before a final decision was reached, for reasons he spells, or there may be more reasons, but the principal reasons are those set out in paragraphs 49 and 50, that there's no diagnosis. He noted the COVID interruption. She's currently in a mainstream education setting, and any further investigation would involve a delay. So he was content to deal with the matter on the basis of the concerns, which were not specifically, more particularly diagnosed.
I agree, my lord. In the point that I make, my lord, the court ought to have carried out further investigation, because we know that assessments were imminent in the near future, and this was a long-term welfare decision that was being made. And the judge observed in particular paragraph 149 that the father would make the correct decision that his child focus to provide further help to the child if she requires it, which may include returning her to the UK, and he accepted the father's evidence on that point. And the point that I respectfully make, my lords, my lord and my ladies, is that if the court is prepared to accept the father's evidence, that the father will return the child and the children by extension, effectively, then that it seems to be much more in the best interest of the children for all inquiries to be completed now. Because if it would mean that it transpires that the child has more serious learning difficulties, and that it is then deemed that the child should be returned back to this country because the provisions are more satisfactory, then that would interrupt the lives of the children, and would appear to be a factor of relevance in the overall welfare assessment, as opposed to going for a much more speedier option, is to proceed without having to wait for the assessment in November 2023. And there are a number of sources which the judge engaged with quite effectively about the evidence that suggested there were concerns about the child, and the judge rightly acknowledged those concerns. But in my submission, that proportionality in the best interest of the child demanded that investigation be completed, given the concerns, before a final decision in respect of the summary order was made. I'd like to take my lords and my ladies to one particular authority, and that is the Respondent authorities bundle.
This is paginated.
Thank you. It's page 89.
Some of it is.
Thank you. Paragraph 38.
This is the one bit that isn't. Is this Mr. Justice Cobb?
In the case of J against J returned to unconventional country. Yes, Mr. Justice Cobb, my lord.
And so we're looking at paragraph
38.
38 in J&J.
Yes.
Thank you.
Thank you. In that case, Mr. Cobb referred to the authority in RE and Y, and he talks about the court's inherent jurisdiction. In relation to, I understand summary return proceedings. And at paragraph 38 in subparagraph IIA says, talking about the 8 linked
I'm
questions.
slightly lost. In paragraph 38 of the judgment in J&J,
Yes, my lord.
where we're looking at what he says about re-NY.
Yes,
And then he summarises what counsel had said about the 8 linked questions posed by Lord Wilson in that case. Which one are you looking at?
Thank you. The third one, my lord.
Number 3.
Yes.
In order sufficiently, that one.
Yes.
Thank you. Sorry, it's my fault.
No, no, no. Thank you, my lord. And the question that was considered there was that in order sufficiently to identify what the child's welfare required for the purposes of a summary order, an inquiry should be conducted into any or all of the aspects of the welfare specified in Section 1.3 of the 1989 Act. A decision has to be taken on the individual facts as to how extensive that inquiry should be. The court no doubt will be familiar with the elements in Section 1.3 of the 1989 Act. I can take my lords and my ladies to it if that assists. But the point being, my lord, that the inquiry ought to have been greater than that which was conducted.
Well, in this case, you're referring to the welfare checklist.
Yes.
In this case, the judge did carry out a welfare checklist analysis, didn't he, at the end of his judgment? Right.
He did, my lord. I accept that. The proposition being, my lord, that the assessment wasn't proportionate in light of the facts in relation to this particular child and her particular conditions, such that the further assessments ought to have taken place before the conclusion of the final hearing. Right. Thank you, my lord. That's the point.
The point you're making, I think, is that given that there was evidence before the court which the judge accepted that there were concerns about the younger child and her development position, the judge says, well, she may not have a developmental problem and hopefully never will. It won't be diagnosed, but I'm not putting it off for an assessment now because I think I can deal with it and it's going to cause delay. And I think your point is, well, supposing that the diagnosis went the way that everybody feared it might, rather than the way that the judge hoped it would go, then it seems to be accepted that that might result in the child being returned to the UK from the UAE because father says that's what he would do. And that would cause more disruption, which would inevitably impact on the welfare of the children. And given that that scenario was out there, the sensible thing to have done would have been to have put it off and have a final decision by the professionals about a developmental position, so that there is certainty by the time you carry out the welfare checklist.
Yes,
is that the point?
That's precisely the point, yes. And then, my lady, to ascertain the position in UAE in terms of what support there is available for children of those conditions. Thank you, my lord and my lady. The other strand of this ground is the paragraph 12, and that's the adjournment application in an LSPO application for this is the legal.
What? This is a genuine inquiry.
Yeah.
I'm not trying.
Yes.
I don't know the answer to this question because I haven't had a chance to look. What power did the court have to grant a special services payment order in this case?
Sorry, well, the question is, what part does it?
What power did that?
What power?
What power? Do the provisions about special legal services payment orders extend to this type of litigation?
We had a discussion with our own friend before the hearing, my lord, and he agreed that the High Court does have jurisdiction to entertain an application for.
In what cases? All family cases? Can I tell you what my understanding is, that I haven't had a chance to check it, and I could well be wrong, Mr. Fassler.
Yes.
My understanding is it's under section 20. It's a 22 ZA or something like that of the Matrimonial Causes Act. It's confined to matrimonial causes, i.e. divorce proceedings and ancillary financial relief, or maybe broader than that. But my assumption is it's confined to certain types of family proceedings and do not include proceedings under the inherent jurisdiction of the return of a child. Is that right?
Yeah, that's my understanding.
So what power, in those circumstances,
Yes.
what power did the court have to make a legal services payment order on this application by the father for return of the child to a non-Hague country under the inherent jurisdiction?
The court did entertain the application, my lord, in the decision. It gives reasons for why it was not prepared to make an order.
But that's not with respect in answer to my lord's question. If the court didn't have jurisdiction to make the order in the first place, you can't complain that it didn't make one.
Yes, my lady. My lady, I think my knowledge of this point is very limited. Perhaps it's something I can address, my lady, my lady, my lord, later in my submissions, or perhaps after my next.
What had happened in this case is that the father had made some contributions.
Yes.
And there'd been some sort of deal reached about cars, which were going to be sold.
Yeah.
And that never happened.
Yes, my lord.
So, but your client had a hope that he would pay.
Yes.
But no, at the moment, I'm not persuaded there was any power in the court to make him pay, because the statutory provision, which exists for very good reasons in matrimonial finance cases, do not extend, for better or worse, to this jurisdiction.
Thank you. But if my lord and my ladies permit, this is perhaps a point that I can address you later on, perhaps in the course of the.
I think we should move on.
Thank you, my lady. My lady, a part of that strand is also the adjournment application. Adjournment application was made to secure legal representation, and that was declined. And the part of the judgment dealing with that point is page 55.
Well, what this case does illustrate, Mr. Fasley, is the extremely unsatisfactory situation about qualified legal representatives. I don't know to what extent my colleagues in the Constitution are aware of this. We haven't had a chance to talk about it. But those practicing the family jurisdiction are all too well aware that this provision is not working satisfactorily.
Yes. Yes, my lord. And that's a complaint, my lord, that
there aren't enough legal representatives.
Yes.
And the professions say the reason for that is that the remuneration rates are just not feasible.
Yes, my lord. That's the. Yes.
No problem with that, I'm sure.
Yeah.
No, Lord, of course, and Lord, it's already observed, and we've observed in our skeleton that strenuous efforts were made by the court in Cardiff, but also the High Court in London, to obtain the QLR for the mother's representation. In fact, one was found for the May fact-finding hearing.
Yes.
But at that time, the mother was then represented by counsel and solicitors, and so there was no need. When we got to August, not only was there a dearth of QLRs available, but of course it was the holiday, and so it made it even more difficult. And despite, I have to say, strenuous efforts all around, it's simply impossible to obtain a QLR that day.
Well, this is a matter of great concern to I know, to the President and to family judges generally. Anyway, the fact is your client was hoping to be represented.
Yes.
And that never happened.
That never happened, my lord. And paragraph 12, my lord, page 55, the appeal bundle, the judge addresses the application to adjourn to secure representation, and he declined it, but he didn't set out the reasons. He gave an extempore judgment. Those reasons are not set out in the main judgment, from what I could ascertain. And we know, my lord, that the court had properly arranged for a qualified legal representative to cross-examine the father. Unfortunately, the court was unable to secure those services, and that's paragraph 21 to 23, page 57. And I make the point that Mackenzie Fraser is no substitute for a legally trained person, particularly given the nature of the hearing, and given that it was a finely balanced decision, both from Kafka's but also from the court itself, my lord, that having a legal representative is likely to have made a material difference, particularly given the mother's conditions and the vulnerabilities, including by reasons of language.
What do you say about the judge's comment in the last sentence of paragraph 23? I mean, the judge, by this point, the judge was very familiar with this case and these parties.
Yeah.
He'd reached a very nuanced judgment on the fact-finding hearing, by which I mean he'd made some findings in respect of the mother's allegations, but not, as it were, the most serious findings. Some serious findings, but not arguably the most serious.
Yeah.
He knew the couple well. He was in the best position to evaluate whether, in the context of those findings, your client was going to get a fair trial, given in these circumstances. And his conclusion is that this was a suitable alternative. Why do you say? What basis do you say this court should conclude that was wrong?
We know, my lord, from Ms. Dixon's witness statement that she was concerned about her own ability to assist the appellant, particularly also by reasons of time. She didn't have enough time.
Why, with respect to Ms. Dixon, why was she in a better position than the judge to evaluate that? The judge, after all, could survey the whole canvas.
Yes, my lord. That's a proper and accurate observation. I'm grateful, my lord, for raising it. In my submission, by reasons of the outcome of the decision, to which I'll come to perhaps in the second round of my challenge, when I talk about the welfare system being flawed, that there was evidence, my lord, from Ms. Hamad, but also from the father, and Kafkas in particular, that could have been challenged more effectively in respect of putting the mother's case forward and challenging.
So you're going to say that this part of best illustrated when we go through the specific grounds on welfare.
Yes.
Okay.
Yes, my lord.
Points on welfare.
Thank you, my lord. And I say that it's clear from the welfare assessment that there was a need for cross-examination that didn't take place in this case, and that may well have changed the outcome of the overall conclusion by Kafkas and by the court. I've also referred, my lord, paragraph 15 of my skeleton argument to the appellant not being able to put questions to Ms. Hamad on the position in UAE in terms of the law, those being her primary concerns as to why she can't return there, and those were for reasons of non-payment. And again, that was a further reason to perhaps consider adjourning the matter for this to enable the appellant to secure representation, even if through a QLR.
Well, the judge, forgive me, should we just look at what the judge said about this point?
Yeah.
I think we may be at paragraph 34 of the judgment. And forgive me if I'm in the wrong place. There may be other places. This is where the judge is dealing with Ms. Hamad's evidence, which is the point you're now making. And he recites in paragraph 34 what happened. doesn't he? That's where he says.
Yes.
So where do you say he went wrong in that sequence?
So the judge, my lord, made appropriate allowances in the form of a 7-day period for the matter to make questions. And I accept entirely, my lord, that's a generous period of time in which for the appellant to prepare. The appellant says that she didn't put questions to the expert because she did not know what questions to ask. And she relies, by reasons of her mental health conditions and her inability to come up with this question is the reason she puts forward her vulnerability. And that perhaps suggests, my lord, that this was a case that required somebody legally trained to assist the appellant to protect her position. Even if a party fails to put forward a question with a court's allowance, a reasonable allowance, perhaps a generous one, in my submission, my lord, there is still that room where, if the interest of a party, particularly a case of this nature where the court is primarily concerned with the best interest of the children, is concerned, all efforts should be made to ensure that in the quest to protect the best interest of the children, that the parties are on equal footing, so that all evidence can be properly scrutinised.
The QLR would have been, I just remind myself, just if I may, the QLR would not have normally been, in fact, would not have been able to put questions to Ms. Hamad. QLR's role is confined to cross-examining, or maybe examining in chief, I think, certainly cross-examining the parties on domestic abuse issues. So the QLR route wouldn't have helped here.
Yes, my lord, that's right. But he may have enabled the appellant and adjournment to seek alternative sources of assistance, for example, through the Bar Provena unit or elsewhere, to provide representation at the hearing.
So this is a limb, actually, of your vulnerability ground,
Yes.
in a way.
Yes.
Because you're saying because of her vulnerability, she wasn't able to formulate these questions herself.
Yes.
And that highlights the need
Yeah.
that for there to have been an adjournment so that she could have obtained
Yes.
legal assistance.
Yes, yes, Marie. And I accept, Marie, that in other proceedings where the court is concerned with dealing with two adults, the position might be different. But when the court is concerned with dealing with the best interest of the children, the primary focus of the court is on those considerations, how best decisions are made on the evidence that there is.
Did Ms. Hamad, she gave evidence? She didn't give evidence. So were any written questions put to her by the parties?
My lord, she provided an initial letter setting out the possible how an assessment agreement would work in accordance with the guidelines set out in the Paul J judgment. Further questions were then clarified in light of the mother's concerns put in her statement as to fear of arrest, fear of prosecution, fear of not being able to leave the jurisdiction.
Were those questions drafted by you and all the father's team?
Yes, and they were put to Miss Hamad. The court had those and then invited the mother to ask further questions.
Okay.
And gave a timescale.
And is it your case that your questions focused on the concerns that the mother raised?
Did. They absolutely did, because that was information the court required.
You were trying to close that argument off.
Indeed.
And they were all answered in writing by Ms.
They were
Hamad.
all answered right. There's an
Hamad.
addendum report from Miss Hamad, and then she wasn't able to give evidence at the first part of the final hearing because of the shortness of time. But the court invited the mother to ask further questions if she required. And then on the 17th of August, the mother was chased by my instruction solicitor, Miss Nussel, to say, do you have any further questions? And the response was, I do not have any further questions. Nothing was raised by way of vulnerability. Nothing was raised by way of I'm unable to ask those questions, or I need more time.
Thank you.
Thank you. But there's one further authority of my Lord Justice Baker in the case of a child withdrawal of treatment, legal representation. 2022.
Is this in the bundle?
It is, yes. It's in the Appellant's bundle.
In your bundle,
Appellant's Orange bundle, yes.
and it's a child,
Yes.
so it's the second case.
Is this the end of life case?
Yes. My Lord, my Lady's paragraph 43, which effectively observes the question to adjourn is one of fairness, and that's really the point, my Lord, which is not in dispute. And so the submission is that fairness in this case deserved or demanded rather for the matter to be adjourned, for all those defects to be rectified before the final conclusions were reached. And the final point about this ground, in relation to this ground, my Lord, is the point about the interpretation issue, interpretory issue.
Could I just, before you leave this case, I mean, without in any way wanting to understate the importance of this, the current case, obviously the VA case is in a different category.
Absolutely, my Lord. I'm very grateful for that resolution. Yes, it was just the point about fairness, my Lord. That in the German application, generally, it's the fairness principle that is considered. My Lord, the point about the interpreter again is a difficult one. It's quite an unusual position in which the appellant finds herself in. She feels that she required an interpreter. The court, page 56 of the appeal bundle, dealt with this issue at
Paragraph 20.
paragraph 20, yes. The judge observed that her English is excellent.
So again, Mr.
Yes.
I mean, this here the judge had known, had experience of your client for some time.
My Lord, I'm grateful for the observations. That is the case. At paragraph 17, the appellant's position is that when she was asked how much, or rather, what she feels about an interpreter, and she said she didn't really use an interpreter in the past, is what she suggested. And really, the only part that I can raise before this court is that she was under the impression that she herself would not be questioned. And that's why she had agreed that an interpreter was not required to interpret.
So you accept that she said what she's said, is recorded as saying in the last sentence of paragraph 20?
Yes, my Lord, she did say that. Yes.
But you're saying that when she said that, she didn't realise she was going to be asked
She
questions.
didn't realise she was going to be cross-examined, And to a degree also, my Lord, she didn't appreciate that the interpreter was going to be very useful to her in her quest to advance her position before the court. Because we know, and the slight difference between this hearing, my Lord, was that she didn't have a legally qualified representative at the final hearing. And so even if, as there was no interpreter in the fact-finding hearing, which would have been far more challenging in this hearing, she was represented by counsel and solicitors at that hearing. Paragraph 18, I've just made submissions, my Lord, on the practice direction 1A principles of vulnerability and other points which are there. That's all I wish to say, my ladies and my Lord, in relation to ground 1. With the court's permission, I'd like to move on to ground 2.
Thank you.
Thank you. And that is a challenge that is perhaps best captured by the grant of permission of my Lord Justice Moylan. And the complaint is that the court below failed to have adequate regard to all the facts found in the fact-finding judgment against the father when making the final welfare decision. Specifically, there was heavy reliance, as is usually the case, on the Kafkas' updated report, in circumstances where the author of that report has not explicitly referred to or factored in the adverse finding made against the father before arriving at her conclusion. The court made a number of findings adverse to the father, but then it failed to have adequate regard to some of these facts when determining whether it was in the best interest of the children to return to the UAE. I've set out those findings that address to the father at paragraph 19. My lords, my ladies, have a moment to perhaps read those, and I can come to the submissions.
I think we've all read the fact-finding judgment.
Thank you, my lord. And the particular paragraphs referred to are set out in those paragraphs that I've set out. Paragraph 19 is that paragraphs. Now, in determining the children's long-term welfare and best interest in the final hearing, the court below, looking at page 76 of the appeal bundle, and going all the way to page 89, paragraph 33 to 126, relied on the Kafkas officer's evidence.
Sorry, please forgive me. I was just. It
Yeah.
doesn't matter what
Yeah,
paragraph.
I'm giving you the general pages of where this the issue of the Kafkas officer's evidence is dealt with. I'll take you to specifics now.
Yes, I misheard you. Please forgive me. What page? What paragraph?
Page 76 to 89.
Thank you.
Thank
Which
you.
is, you said, I think, paragraph 73 to 126.
Thank you.
Yes.
Sorry about that.
And so it's clear from those that heavy reliance placed on the Kafkas report, and we know from paragraph 74 on page 76, where the judge makes it clear that he has probably taken into account the court findings, fact findings.
You challenge that, do you?
I do challenge the Kafkas taking into account, my lady, yes.
Do you say, well, there's no mention of the adverse findings about the father, so how can the judge be satisfied that she's properly taken it into account?
Yes, my lady. There is some mention of it, and I'll take you to specifics now. And also, on that point, as I've cited at footnote 2 of my skeleton on under paragraph 20, is other places where the judge accepts Miss A's evidence. So page 102 is one such place. And paragraph 185, she says, I accept Miss A's evidence that she bears the greatest responsibility in this respect. And then it talks about the position of the mother and how the judge is pessimistic about that, as was Miss A. And also page 103, paragraph 188, yes, and where Miss A's evidence is accepted again by the judge, and really it seems that almost all of her evidence was accepted in the welfare assessment. Now the difficulty with that is that in the updated report, this is before the fact-finding hearing, in the updated report, sorry, after the fact-finding hearing, taking into account the fact findings, she didn't take into account all the findings that were addressed to the father, which were, in my submission, very relevant.
I'm looking at paragraph 3 of her report on page 428 of the bundle. Actually, I'm looking at paragraphs 2 to 4, which summarizes in this is the addendum report prepared by the Kafkas officer following the fact-finding hearing. This is July this year, and what she says in paragraph 2, 3, and 4.
Yeah, as well. I mean, I've read those, my lord, and they don't take into account all the findings that I've set out that were found by the judge. Paragraph 19 of my skeleton. So she talks about there being significant coercive and controlling abuse. That finding wasn't made. The sexual abuse finding wasn't, which is right. And then it talks about
financial abuse.
Yes.
And both parents capable of initiating aggression towards another.
Yeah.
And mutually verbally abusive.
Verbally abusive, yeah, but no mention whatsoever of the points that you've
of the physical assaults.
So what she said in the first sentence at 3 is declined to make the worst findings.
Yeah.
Misses out, but made some pretty serious findings against father.
Yeah.
And then talks about financial and verbal abuse.
That's what my lady, the report is focused on, is primarily the financial abuse. But as I have set out in the paragraph 19 of my skeleton, the point at, for example, point at C, for example, the father was capable of appalling behaviour when under the influence of alcohol. I'm entirely satisfied that urinating into the kitchen sink took place. For example, the paragraph F, father told the mother if of back to the back here, and this is the kind of behaviour that's capable of employing. And paragraph H, the father threw her against the walls of the family home and the furniture in a rage. She locked herself in the bedroom. Following morning, he threw her and leapt out of the home until the police arrived, and the medical report was referred to. And the point at I, the father regularly held the mother in contempt, sent her derogatory messages, verbally abused her in a shameful way, calling her, and that language is there. And the point of paragraph J, during argument, the father had made threats to kill her and bury her in the garden. And this was an unpleasant, abusive incident. She had by then been exposed to a sustained abusive relationship with him. K, the father exercised a degree of unhealthy control over her in relation to finances. That point was referred to.
The judge doesn't refer to those in detail. She rolls. The calculator. There's paragraph 2 and 3, 2, 3 and 4, and then there's paragraph 15 on page 431.
Yeah, yes.
When she talks about that she's in no. The judgment illustrates the concerns about the levels of dysfunction that the children have been continuously exposed to. No doubt that both children sustained emotional harm resulting from the acrimony which they have become accustomed to between their parents, growing up witnessing aggression and conflict, and instability, etc.
Yes. And there's reference at 22 as well to exposure to parental dysfunction and conflict.
It's all, so your point is, I suppose, it's all in general terms and doesn't convey the seriousness of the specific findings that you've identified in paragraph.
Yes, well, which I say were relevant to the welfare assessment in the long term, looking at the father's behaviour in the past. And particularly
when there's a provision, when she's talking about the younger child, she says that the younger child is scared of physical chastisement by the father, page 429, paragraph 8.
Yeah.
And there were findings were there not about physical chastisement in the
Yes, there were.
past?
So, yes, well, so the fact when hearing as I've said out paragraph the judge found the father threatened one child with a fork before pressing it in his hand, causing him to cry out, and there's evidence of propensity to use an object as part of physical chastisement. And at the paragraph in the court was satisfied that the father hit one child with a phone, and that she had made dirty, causing an injury to her head. That was also a finding made by the court below. That wasn't factored in.
So we've got the same child who's been subjected to this violent treatment by way of chastisement, saying she's afraid of her father, and the report, the person who wrote the Kafkas report has not factored in the fact that he's done it before.
Yes. There are two findings that I've summarised. One was that the father hit one particular child, which is different to the other one, with a phone that she had made dirty, causing an injury to her head. And the second finding is that the father threatened another child with a fork before pressing it into his hand, causing him to cry out. There is evidence of propensity to use an object in part of physical chastisement. I've quoted the relevant paragraphs in the decision referring to that. And it's a submission, my ladies, that this materially undermines the best interest assessment of Kafkas, and by extension of the court below, because the court relied on that assessment heavily.
Well,
Yes.
let's just, this is really the key point of your case, isn't it?
Yeah.
So should we just
Yes.
dissect this, if I may, Mr. Paisley?
Yes.
So we've got you've attempted to illustrate that the judge, that the Kafkas officer, speaking in general terms about the findings in the judgment, did not focus or refer to the specific matters, a number of the specific matters you refer to in paragraph 19.
Yes.
Of the skeleton. And then we have what the judge said about that. He, and help me where that is.
Yes, I will do.
Where does he deal with with the Kafkas officer again? I've lost it.
It starts at paragraph 73.
The
73 is 126.
The lady's told me that 3 times now. But not remember it. 70. Right. Okay.
Starts at 73.
Then,
It's really 724. I'm satisfied she's properly taken into account the court's findings in relation to the parents as part of her analysis. Where has she?
My lord, it's paragraph 83 of the decision.
yes. Did she give any oral evidence about the findings?
Yes, my lord.
I suppose you're not in a position to help us because.
No, my lord. I was in the court below.
You were taking us to 83.
Yes. Maybe I'll. Paragraph 79. Sorry, paragraph 83, page 79. Here the judge was referring to paragraph 16 of the Kafkas report, upon which he was placing reliance. And that refers to the financial abuse that was experienced. And not all other aspects of abuse. And similarly, paragraph I think the other paragraphs, as my lord suggested, paragraphs 3 to 4 of the Kafkas report to which we looked at, and paragraph 26 of Kafka's report as well, which demonstrated not all of the findings were considered.
But if we go back to page 79 of the bundle, paragraph 84 of the judgment,
Yeah.
the judge says each parent indicated forcefully to Miss A negative views about the other. Father described mother as neglectful, etc. Mother alleged that father is ambivalent in terms of commitment to the children. And then the judge goes on, in reality, bluntly, both parents emerged poorly from my earlier judgment. And so, do you say, what do you say about that sentence? Is that enough to suggest that he had in mind all the matters that he had decided before?
In my question, it is insufficient, my lady, given the specific findings made, and given that the court was relying primarily by the professionals, Kafkas in this case, to ascertain the wishes and feelings of the children and the welfare checklist determination by reference to the evidence.
Is your case, is your point you're making, maybe there are 2 points.
Yeah.
I understood your point you're making at the moment, to be the judge relied heavily on Kafkas officer.
Yeah.
Kafka, in doing so, he was wrong because the Kafkas officer herself attached insufficient weight to the findings, the serious findings you highlighted, paragraph 19.
And failed to take into account, my lord, some of the findings.
Yeah, so that's point one.
Yeah.
There's a separate point, is whether the judge himself failed to take those findings into account separately.
Yes.
You say that he did?
Yes, I say that.
On what basis do you say that?
I say, my lord, that he wasn't alive to all the findings, and the basis is again the point that the judge quoted passages from the Kafkas report without referring specifically to all the allegations that he has found proved in the fact-finding judgment.
He deals with it separately. At the top of page 76, paragraph 69. So the judge has well in mind the fact that the father didn't emerge well in terms of assessments of his credibility in fact-finding judgment. Neither did the mother.
Yes, my lady. Is the specific findings of abuse that the judge found, which I say were not explicitly referred to when assessing the best interests of the children.
This is a very thorough judge.
Yes.
And unsurprisingly, we see at the beginning of his judgment the statement that paragraph 4, this further judgment is therefore designed to be read in conjunction with that earlier judgment. So we're talking about 2 judgments. He says it's all one, really.
Yes, my lord, I noted that, and I noted that he was certainly aware of the judgment. My complaint is that because he has relied, as is often the case in Kafka's recommendations were defective because those themselves were based, it appears, on an incomplete reading of all the findings that were made against the father, which were relevant directly to the issue of the long-term future of the children. And that's where the defect arises. The judge clearly says that he has in mind his judgment, but in my assumption he was required to engage, for example, the findings that he made with respect to the children who had endured some abuse from the father, how they're going to impact them in the long run in the welfare assessment.
How do you then deal with how the judge dealt with the oral evidence at 101?
Page or para?
Paragraph 101, page 83. The judge isn't just relying on the report, which may have certain deficiencies in it.
Yes. Yes, my lady, yes, I'm grateful that the judge has referred to the issue of chastisement, but they were apart from the other allegations, for example, of violence found proved against the mother.
Yeah. There's no particular reference in that in relation to paragraphs 19 in paragraph 99, which was the passage in the judge's judgment that deals with the fact-finding judgment generally. Again, it appears that the witness, the Kafkas officer, is focusing upon finances rather than physical abuse and verbal abuse.
Yes.
And the most you get is that she's formed a view that each parent's capable of behaving badly towards the other, to which the children have been exposed, but of course there's a difference in the quality and nature of the bad behaviour.
Yes.
And the fact-finding.
Yes, my lady. And perhaps, my lady, the case would be different if the differences were starred. But this was a finely balanced case, and I'll take you to the bits where the judge and Kafkas took their view. So in those circumstances, it was paramount for Kafkas to take into account all of the findings before reaching her recommendations. By paragraph 22 of my skeleton, I'm referring to the passage from the judgment at page 61. Subparagraph XI. This is referring to legal principles in a summary return case. And one principle that emerges, that is set out there, is that when considering the issue of summary return, then the impact on the primary carer must also be relevant, although again not decisive. And in my submission, the impact on the mother of returning her children to the UAE, particularly in light of her vulnerability and the abuse that was found she had experienced, has not been adequately considered in the final judgment. And the focus has been, which is right, on the best interest of the children, but there was a requirement under the law that regard must be had to the impact on the mother as well. The court found that this is in the fact-finding judgment, that the mother's rights in the UAE were extremely limited, and that her position was inherently and fundamentally inferior to the father, and that he knew that. This is at page 186, paragraph 214. And the court also referred to the mother's lack of rights in fundament and vulnerability in UAE. This is page 189, paragraph 225. These observations were made in the fact-finding hearing, but they don't appear to have featured into the final hearing in respect to the welfare and the impact on the mother.
Is that not because it was accepted that she would not return to the UAE, at least while married to the father?
The mother's position, my lady, was that she can't return to the for reasons she gave, which were not accepted by the judge.
My lady's point is that when considering the adequacy of the judge's analysis of the mother returning,
yeah,
you have to take into account the fact that she said she wasn't, and it was accepted that she wasn't going to return, at least when she was married.
Yes, my lord, and also, my lord, that the judge was required to take into account the impact on the mother as a primary carer, at least for now, and her position in the UAE was a relevant factor to take into account. And what's referred to in the fact-finding hearing, it hasn't featured it.
I think, with respect, you haven't quite got the point.
Yes.
It can't be a relevant factor if she's not going back to the UAE, and it was found that she wouldn't, for whatever reason. So the impact of going back to the UAE on her is now an irrelevant consideration because she's staying in England or going somewhere else.
And that's paragraph 86 of the judgment. And also at 87 at the beginning, the judge says, however, apart from the mother's legal position in the UAE, and notwithstanding the negative points about the father, etc., Miss A's assessment is, etc.
Yes, I think
you're at the other end of the telescope, aren't you? You're saying before it wasn't. You said, well, maybe I'm not saying this, but one could say in your position that rather than merely accept her assertion that she wasn't going back,
Yeah.
the judge should have looked behind it. I suppose this is what you could say. Look behind that,
Yeah.
and because there was a good reason why
Yeah.
she wasn't going to get back, to take that into account and evaluate it.
Yes, well, and also, my lord, Miss Hamady's evidence was that the mother can return to the UAE, and there'll be no charges, and they were proposed and considered by the court as to the methods or the ways that she can employ to be able to return, including by being able to, for example, obtain an employment visa. So that was a possibility concerned by the court. I'm sure my friend will be in a better position to comment on this.
Right.
And so, yes.
But as you say, your point is that we should be looking from the other end of the telescope, as my Lord Justice Baker put it, i.e. from the position, the impact on the primary carer.
Yes.
And that's the phrase you use in paragraph 22 of your certain.
Yeah, yes, well, and the point was that she is in an inferior position anyway because of the laws of that country. And that is a factor to take into account. And the judge was probably right to take that into account in the fact-finding judgment. There's no reference to it appears to me, in those terms, in the final hearing. And again, if the appellant had been representative, this would have been a question put to Miss Hammett, for example, to set out the position in terms of inferiority for women in that country and what restrictions there are there. On the finally balanced decision, I've set out paragraph 24, a reference to page 75 of the appeal bundle. And paragraph 68, where the court puts out that Miss A, capital, was anxious to indicate more than once that she found a professional task in this particular case very challenging. Describe her recommendations as finely balanced. And similarly at paragraph 80, paragraph 88, page 80. The judge refers to Miss A's analysis and says, frankly, a depressing qualification which came with her analysis. And I quote that passage from 20 of her report. Regrettably, the court is now faced with a choice which involves balancing which option is likely to end up being the least harmful. And I hold concerns about their long-term well-being based on either possible outcome for them. And a paragraph 89 of the judgment the judge, referring to the evidence of Miss A, says that the father can offer Miss A found or observed that the mother is likely to be unable to protect the children from adult disputes and to promote paternal relationships, but that the father can offer some limited self-reflection about his part in the harm and have held a slightly higher degree of respect and courtesy towards the mother. And that came to paragraph 90. And then at paragraph 114, page 86, the judge referred to the evidence of Kafka's in the hearing that she accepted that if she had been satisfied that the mother had been genuinely willing to promote the father's contact, then this may have shifted her recommendation for the children to remain in this country. And we know also on that finely balanced position point, my lords and my ladies, that one child, Kafka's found, would accept either to live in this country or in the UAE, and that's page 99, paragraph 267, which again is there. And the court found both parents love their children. That's a finding at page 180. And given the finely balanced nature of the decision, in my submission, that the failures of considerations by Kafka's, which were then relied upon by the court below, amount to a material error of law which made a material difference to the outcome, given the issues were very narrow in the case, really turned on slight consideration between the parties.
I think, unless you have anything else to say about that, I think, given the time, we need to move on, Mr. Fazley. And unless there is something that you would like to add.
No, just final point, my lady, that given the issue was attitude of the matter, and the tip of the balance, one can't say the conclusion that the language difficulties may well have factored into that point.
Could I just raise one? You don't say this is the case where the judge didn't carry out a thorough welfare analysis. You say that his welfare analysis was undermined by the failure to take into account certain factors, or failure to give weight to certain factors, the ones you've gone through.
Yes, well, that's the point. Thank you. My lady, ground 3 is a very brief ground, which is the mother's immigration status. We know she has limited leave to remain in the UK, and the judge dealt with that at page 74, paragraph 61. And the mother secured her status, it seems, on the basis that she's a primary carer for children who are British citizens. And the position is, my lord and my ladies, that if the children return to the UAE as the court ordered, the mother won't be in a position to remain in the UK post 2025 when her leave expires. In fact, actually, even now, she'll be required to inform the Secretary of State for the Home Department as to her immigration circumstances changing in the sense of the basis on which her leave was granted.
She's here as a Zambrano carer, but surely if she's a citizen of Slovakia, she would have had rights to be here anyway.
Pre-Brexit.
Would have. Yeah.
Now, do I take it from the fact that she's relying on Zambrano status that she didn't get her act together in time to take account of to deal with the withdrawal agreement?
I think that's my understanding. Yes.
Yeah.
Because they came in the summer of 2022.
Right.
Post-Brexit.
Post-Brexit.
Yes.
Okay, thank you.
So she was subject to immigration control in the same way, my lady, as many other people from other parts of the world. And post-Brexit, her only hope would be if she remains involved in the lives of her children in this country. I know that in the application form she had raised domestic violence consideration as well, but it's understood that the leave was granted on the basis of her relationship with her children and the continuing care that she has for them. And so in my submission, that point is relevant to the best interest of the children. A question that the court did not ask itself as to what would happen if the mother isn't able to remain in the UK. And of course, we know the father is a UK national. He can come and live in the UK without any immigration restrictions.
Your client hasn't lived in the UK before. She's stayed. Oh, am I wrong with that?
On holidays.
Stayed holidays.
Yes.
Because they bought the house in.
Yes.
In the north.
2013, I think.
Yeah, they bought the house. So it's a holiday area.
Yes. I understand.
So, does she? She would presumably go back to Slovakia. That would be
yes.
What would be expected.
Or unless she can secure, if she was able to secure sponsored employment in this country, which again is very difficult, and there's lots of requirements to go through that. If in the event that she was to return to Slovakia, there raises questions about contact and the issues of funding and when and how that is to be implemented in the long term, whether there is accommodation available to her and other considerations. because we know from the principles, my lord, that the impact on the primary care is a relevant consideration to the courts.
But I mean, the order makes provision. The judge's order makes provision for contact.
Yes.
Why would that be any less? Why could that not be applied if she was in Slovakia? Obviously, it would be in Slovakia rather than here.
Yes.
From the children's perspective, what's the problem?
Yeah. The children, my lord, has paternal family in the UK.
They do.
And so it's more convenient for them when they're visiting here to be able to visit the mother if they were ordered to go to the UAE, another family. When considering best interest of the children, it just becomes much more difficult when one parent is living in another part of the world, other families here, extended family. Father has connections here very strongly, comes here. It's just the practicality of those considerations, my lord, that haven't been featured into the decision.
Practicalities of the problems resulting from her immigration
status. And her possibly being forced to return to Slovakia, my lord, yes, is the challenge. My lord, Grand 4 is a challenge to the fact-finding here. I knew that decision wasn't challenged within the time frame when the decision was handed down. My instructions are, my lady, that the appellant became unrepresented shortly after that hearing. In her notice of appeal to this court, she had raised a challenge to both decisions. I'm not sure whether my lords and my ladies would want to hear me at this point, or that they're not willing to detain it.
What does he want to say? It's all set out in your. It's all set out. It's all set out in what you want to say in paragraph 26 and 27, isn't it? You've said what you said there.
Yes. Yeah.
I mean, this isn't at the forefront of your.
Yes.
Is it?
It is for me. It's been relied upon in the final hearing, my lord, in the sense that it just has referred to it. But the rules permits the appellant only to challenge that decision at the time that it was made, and shortly thereafter. And that hasn't happened, and the court is aware of the reasons for that.
I mean, there was no appeal.
No.
The client was represented at that hearing.
Yes.
And presumably well, you know, when she stopped being represented.
Shortly thereafter, my lord.
And the points you raise are quite limited.
Yes, they are, my lord. I accept that entirely. Yes. I mean, I can leave it as they are pleaded without developing orally.
I think that's a good idea.
Thank you. My lord and my lady, very grateful for that.
Round 5.
Again, that goes to the other point. I'll leave that there, my lady. It's simply that there were one or two places where the judge decided not to make findings either way, whether they were found proved or not proved, and simply left matters as they were. And I'll leave that there as well.
Thank you very much, Mr.
Great,
you've said everything you want to say?
Yes, my lady.
Thank you.
Thank you.
Thank you very much. Mr. Johnman?
Lady, it's probably convenient if I just go through in answer to the grounds that have now been submitted in my learned friend skeleton argument. In relation to the PTSD issue, I think you've now been sent an email which purports to be medical evidence that was put before the court.
Well, we certainly haven't got it.
I haven't looked at my emails.
No.
It is here, but I haven't looked at it.
Yes, well, of course, there's no application to submit that. That was not put before the judge. That was not put before the court. It was not sent to me. But we were unaware of any medical evidence. But in fact, I invite you to look at that because it's not dated. But it also makes reference to staying in England and awaiting a court hearing. It doesn't indicate that it's made at the very last day of a very long process of the father's application in August of 2023. The reality was that the mother was not represented. She was a litigant in person. The court had heard oral evidence from her in person in May at the court hearing in Cardiff when she was represented. And every effort was made, either to try and secure a QLR, but also then to support the mother as best as possible. The hearing in August was conducted remotely to assist both parties rather than travelling to Cardiff and staying in the
Why was the case being heard in Cardiff?
Because Mr. Hopkins is based in
I know he is.
as simple as that. and rather than coming to London, the parties were happy to go to Cardiff in the circumstances, which was arguably slightly cheaper.
Okay.
In those circumstances, the court was not aware of a diagnosis. There was no medical evidence in support of that, and therefore the learned judge can hardly be criticised for not taking that into account at the relevant time. But importantly, the mother's statement, which was provided to the court, which is at page 360 of your bundle, made no reference to that diagnosis in late July. That statement's dated the 14th of July. And for the CAFCAS officer, that was also not put or indicated to her when she spoke to the mother during the course of her inquiries in her final report, and that final report is dated the 17th of July.
The document you've taken us to at 363.
360 is
360 to 363 is her position statement for the final hearing.
No, it's it is. Sorry, yes, it is.
It's not referred to there, you see.
It's not referred to there, and I think there's also. I think that's referred to, in fact, as a statement because that was earlier. That's dated the 14th of July. Although it says position statement, that was
And not mentioned. And you said not raised with the CAFCAS officers.
not raised to the CAFCAS officer, not in that position statement, and then referred to as a passing remark almost in the mother's position statement for the final hearing.
Well, sorry. So the position statement at 360.
That although it's called the position statement, I think that more technically should be the mother's statement.
Okay. So there's another
statement, final statement.
So there's another document also called a position statement,
Yes.
is there? Which we were taken to earlier.
Indeed, and that was the passing comment in that, and that is in fact at page 373. And then the mother says, I am concerned I am unable to be a listed in person. As the court is already aware, I am diagnosed with PTSD. Well, the court wasn't aware of that. And it wasn't raised either by the mother or by her Mackenzie friend at the final hearing. The judge was very clear within his judgment, page 57, that efforts were made, further oral evidence was required, extensive oral evidence in May, paragraph 22, efforts to get a QLR. My Lord's point is absolutely right. The role of a QLR is very limited, and it essentially one to protect a vulnerable party from further abuse by cross-examining her abuser effectively, and that's the purpose of the QLR in those circumstances. That was not the purpose of this exercise. Miss Ashton had filed her final report and she was giving oral evidence to that report, and the mother did challenge the grounds of her recommendation in terms of the findings that the court had made in May, in terms of the youngest child's ability to settle at a school in Dubai, particularly with her conditions which had been alluded to by the CAFCAS officer, and therefore the court was, the CAFCAS officer was acutely aware of those issues, and those issues were put to the mother in cross-examination through Miss Dixon.
On the findings point, you said that there was evidence given by Miss A about the findings.
Yes.
Are you going to come to this now or later?
Well,
what's said is that this is really the key. This is underground too, so maybe you have to come back to that.
Well, my Lord, I'm happy to deal with it. I mean, essentially, we say the judge was very careful, having dealt with these parties in various hearings since February of that year, or this year, an aborted final hearing in February, another directions in April, fact-finding in May, etc. He was acutely aware of these parties. At no time did the mother, whilst requesting an interpreter, in fact use the services of an interpreter. The family language is English. The mother and the children speak English together. In Dubai, English was the language. the interpreter was available for the final hearing. She was there throughout the whole of that first day. At no time did the mother request any clarification or assistance from the interpreter. In those circumstances, the judge said, essentially, what's the point of the interpreter being here if you're not going to use it? Do you still wish the interpreter to be here? And the very clear answer was no. The further evidence was in relation to what the mother sought to assert by way of the educational provision in Dubai. The father answered that in his evidence, page 348. This was the school in Dubai for the children to return to. It makes clear it was an exclusive approach, including special needs, dyslexia, page 350, certificate from the British Dyslexia Association at 351, and at 358, a CV of a teacher that the father was proposing to employ to support the youngest child in her transition back to school, noting in the Kafkas report at page 427 the evidence from the school as to that particular child's difficulties, and that's set out in the page 427 within the first paragraphs, the Kafkas officer's contact with the school. And it's at that point that there was a concern that the youngest child may be of low ability. But as the court rightly put in its judgment, it noted that this was a child who'd been in mainstream education at a state school. The evidence from the school was that she had settled very well, she had made friends, and there was no concern that she was isolated or not otherwise thriving within that environment. And rightly, efforts were made to ensure that any transition back to the UAE would accommodate those needs. There was no formal diagnosis, and only at the final hearing did the mother indicate that in fact the child had been subject to a speech and language assessment, which was not known to the father or made clear to the court until day 3. So, my ladies, my lords, that in fact is also dealt with within the welfare checklist of the court's judgment, page 100, paragraph 174, dealing with the educational characteristics, paragraph 74, change of school for children, not be ideal, may be possible for them to go to their old school. If that's not possible, it will mean a return to an expat international school. I expect that this will be a new experience for them. Nothing was particularly found in relation to the support that, or the issues which the mother was seeking to rely on, and that's why the further evidence that was proposed by the mother was not accepted. The findings, my lord, that you asked about, essentially.
Yeah. So my question, the principal challenge on welfare, or a principal challenge, is that the significant findings made against your client were not taken into consideration a by the Kafkas officer, and b by the judge, in part because it was his reliance on the Kafkas officer. And we established that there's no direct reference, so as we could see, express reference to the finding. I'm thinking, in my mind, I'm thinking of the assault which your client perpetrated on the mother, as found by the judge.
Well,
in the presence of the child.
yes.
Now, that isn't referred to in the report, and the submission is that it's either glossed over or ignored. Therefore, that undermines the weight which could be properly attached to the judge, to Miss Ashton's evaluation.
Yes, the Scott schedule's in the bundle, my lord, and you have that at page 197.
Yeah.
You'll see that in the context of the allegations, a lot of those were historic within the course of the marriage. And so, at the time the final hearing was taking place, it was clear. Firstly, the parties had separated.
What was the date of this particular?
So, 2018 is the reference to the
headlock incident.
So, it's 2017, page 199. March 2017.
5 and 6
Yes.
on that page.
Yes.
They are.
Those are the assaults.
Those are the assaults as found against
Yes.
your client.
Yes.
At which point the children were aged 4 and 2.
Yes. The parties remained living together, remained married, remained in Dubai, remained coming to England for holidays until the COVID outbreak. So I don't seek to undermine or minimise those findings, but they were made in context of what was a very toxic relationship during the course of the marriage, where the court made clear it found both parties abused alcohol and both parties were capable of inappropriate, improper behaviour to each other. The Kafkas officer at page 76 the court summarised the findings, and it's also right that the court dealt with an assessment of the Kafkas officer, paragraph 68, highly experienced, extremely conscientious Kafkas officer. Remembering, of course, that this whole process had been derailed to a certain extent by the first report of the Kafkas officer, which said, I don't know what's going on in this family. I'm concerned because of the number of allegations. I'm concerned about the genuine wishes, feelings of the children and the degree to which they are implicated within the parental conflict. And therefore, the court's going to have to undertake a fact-finding hearing. And that was the view of the judge in February, and that's why the matter was adjourned for a dedicated fact-finding hearing in May. So it's within that context that, having looked at the findings, read the judgment, the Kafkas officer then considered her further assessment.
So the whole fact-finding hearing was triggered by the Kafkas officer saying I can't do a fair narration without it.
Indeed. And then, post-fact-finding, written judgment, go to the Kafkas officer, and then she makes her final recommendation. And of course, in the context of those findings, some of which were very historic, some of which, and the majority of which the court did not find in relation to serious allegations made by the mother, the court made the assessment, and that's at page 102, that those findings do not rule out the father, disqualify him from fulfilling a full role in the children's lives, and that's at paragraph 186. Whilst at the same time making a finding that the mother will continue to struggle in this respect if the children remain in her care in England.
So when he says that, you say we could be confident. Are you saying this, that the judge?
I do bear in
Is
mind
that all the findings?
Yes, I do bear in mind the findings I have made against him. However, I have equally found that they do not disqualify him. So he had in mind his judgment, as you've already referred to at the beginning of the final judgment. He says this must be read in context of my findings judgment, and he was clear that, notwithstanding those findings, having considered them, having made them, that they did not disqualify.
Was the second sentence in any way dependent upon the Kafkas officer? And could it be, if so, could it be said that the Kafkas officer did not take into account the serious findings against your client?
The Kafkas officer did take into account the findings, but of course, and my learned friends alluded to those aspects, although they're in summary only, it's a written report and she didn't set out in terms each and every finding.
Was there any oral evidence about this point?
There was oral evidence from the Kafkas officer and put to the Kafkas officer on behalf of the mother, by the mother, that she had not taken into account sufficient consideration of the findings against the father. And I think my lady's point about the child being scared, that was a reference to the first Kafkas report, where the child, it set out in my skeleton argument, the child indicated she was scared of her father in the context of physical chastisement. Notwithstanding that, having spoken to the youngest child again in July, that child was saying, I'm happy to go back to the UAE with my father. And the Kafkas officer noting that neither child, in fact, had a stable attachment to either of these parents. So all of those considerations fell into the judgment the the court made in relation to that. But it also had, of course, its own assessment of the parties, and that's set out at page 165 of the bundle within the fact-finding hearing, where the court very clearly sets out its assessment of both the mother at page 165 and then subsequently the father at page 168. In my submission, the court's judge was entitled to take into account what he describes in relation to the mother, her proficiency in English, for example, no reservations about her ability to communicate clearly with the court. Mother's account before me at times at odds with details recorded contemporaneously by others, and there were police reports from England, for example, in relation to the assault in England. Hesitant to answer questions, and paragraph 114, frankly, a significant change in the mother's sworn evidence in relation to very important aspects of the case relating to a police officer. So,
and similar, not dissimilar findings against your clients.
Indeed, and I don't seek to move away from those. Those are set out clearly.
1, 2, 3 onwards.
Yes. Yeah. And ultimately, the judge said at paragraph 130, in short, my assessment of these two lay parties, I concluded that each of them was unsatisfactory in similar and contrasting ways in their evidence. So neither parent came up very well before this stage. Notwithstanding that, the mother's case was she was not going to go back, and the Kafkas officer was very clear in her evidence and her written report. This was fundamentally the issue in which she determined the children should go back to the UAE. Not only was it in line with their wishes and feelings, even expressed in the preliminary report, but it was a significant concern that this mother was simply not in a position to promote any relationship between the children and their father. And, my lords, that, and my ladies, that's set out within the judgment about the capacity of the parents at page 101. Paragraph 179. And the court sets out the potential of the parental strengths and positives in relation to both parties. But at paragraph 185 onwards, the mother unable to protect the children from the negative views about the father. Continues to struggle genuinely to promote contact, and he was equally satisfied the mother will continue to struggle in this respect. So those were findings that the judge made at the final hearing in relation to the mother, in light of his experience of her giving evidence in the fact-finding hearing, in light of the findings he made, and in light of the evidence from the Kafkas officer about her conversations and the mother's continued stance that she would not return to the UAE. As was made clear from the Kafkas officer's report, that this was a situation that she had already communicated to the children, that whatever the outcome of the hearing was, she was not going to return to the UAE. And in terms of that, the court summarised the mother's position. That's at the beginning of the judgment, page 54, paragraph 9. Continues to oppose the children's return to the UAE. Paragraph 10 set out her reasons for that. In particular, the findings, despite the findings, the father would continue to be abusive and controlling of her, insecurity, etc., etc. The matter was further expanded upon at page 80 of the judgment, paragraph 86. Court noting that the mother has already shared her views with the children. And the court then goes on to consider the position of the mother vis-à-vis the expert evidence of Ms. Amadan about the reality on the ground in the UAE, and that's at page 90, paragraph 130 onwards. And importantly, the court then makes findings against the mother in respect of her position, paragraph 133, also satisfies that the mother's contentions as to a belief that she would be arrested on her return to the UAE is in part tactical in relation to this litigation. I accept the submission and make a finding. There is no rational basis for the mother to hold such a belief. Now, that finding, of course, is informed by this judge's experience of the parties since February of this year. And Lord, sadly, that position was further indicated, as I put in my position statement, during the last half-term holiday when the mother refused any contact from the children's father, despite him being present in England. So, my Lord, we say the court gave a very detailed welfare judgment. It considered at every turn, not only at the final hearing, but also at those hearings where the mother was represented, to enable the mother to participate and put her case to the best of her ability. That was further supported by the assistance of Miss Dixon at the final hearing. It was clear in the judgment the judge took that unusual stance in circumstances where there had already been great delay to the case, but it was proportionate in his judgment in light of that delay and the need for a decision about the children's welfare. And of course it coincided with the end of the summer holidays, where the father's case was that these children could return to the UAE to the beginning of the school term. Notwithstanding that, the judge still held out an olive branch to the mother because he made clear that the children would not go back until, irrespective of her position, there was a settlement agreement in place, allowing and giving protection to the mother to enable a shared care to be put in place should she return, but if not, at least an ability for her to travel and exercise contact with the children in the UAE during holidays or other times. That settlement agreement was negotiated with the assistance of Mackenzie's friend, Miss Dixon. It has been finalised. It has not been signed because this appeal was then pending. But that settlement agreement is drafted, is ready to be put before the court of the UAE, and will enable the condition of the judge's order to be satisfied, these children to return to the UAE, and for the mother to be protected in the way that the court made clear in its judgment.
Right, so that answers one question I have, which is that if we were to dismiss the appeal, what would be the immediate consequence?
The immediate consequences are that, as I indicated, the settlement agreement is drafted, the mother would have to sign it, and then that matter would be put before the court of the UAE. I don't have an update as to how long it would take, and I suspect it probably won't happen before the beginning of the school term. But
when is the school term starting again?
Beginning of January, 4th or 5th of January. I think they break up tomorrow, in fact. And there's no agreement for contact. The father came last week. There's still no agreement for contact over the Christmas period. So I sincerely hope that...
Is there an order about contact?
There's not an order because, of course, it was anticipated the children would have been returned at the half-term holiday.
So, right. So the children... So how long is your client proposing to stay in this country?
He's here for the Christmas holidays.
When did he last see the children?
21st of October for a couple of hours whilst the children were with the paternal grandparents. But he wasn't permitted to see the children at all during the whole of the half-term holiday when he was also here. Lord, I hope that over the election adjournment that can be resolved with any friend.
What do you suggest should happen if it isn't?
Well, in the circumstances, I might have to invite my lords and my ladies to help us with that. There was a previous order, and I'll go back to that, and it may be that we simply ask for that to be repeated.
We've not been told of any reason why there shouldn't be contact.
No, and it's on the basis, of course, as a judgment for the children to go into the father's care. The mother, I think, still anticipates it should be supervised, effectively supervised by the grandparents, and that's clearly fallen away post the judgment if the judgment's upheld. In relation to immigration status, with at page 74, paragraph 61, as you've already been pointed to, that position was that the mother would either return to Slovakia or Austria, but as my lord's already pointed out, and I endorse, it's the point I'd written down, there's effectively a contact order for the children to spend significant time with her in England during school holidays, and it may be that would enable her to remain in this jurisdiction in any event, but the order provides for only the first year of contact to be in England. Thereafter, contact can be anywhere. So if the mother does relocate, it doesn't undermine the order in those terms. And of course, it's hoped that the mother would return in any event to Dubai, where she could work if she wanted to, noting that the parents' parties met in Dubai, the mother's working in Dubai, Dubai to be in her home for a number of years, even before the relationship and before the marriage. We touched on the issue of questions to the expert. I'm reminded by my solicitor, who's watching on the live link, that in fact those questions were not only my questions but the judge's questions, in light of the evidence that Ms. Ahmad had already submitted, and those questions were put with the approval of the judge before they went to Mr.
About, sorry, what issue?
About the protective measures that could be in place by way of the settlement agreement. Well, Lord, in relation to the final aspects of the skeleton argument, we say that the fact-finding hearing wasn't appealed. The judge gave detailed reasons within his judgment as to the burden and standard of proof, and the various references in relation to each of those findings. They were findings that the court had a discretion on which to make or not make, and the judge exercised his discretion accordingly. He was satisfied in relation to the specific allegations in ground 4 that there was insufficient evidence on which to make those findings, and therefore, in my submission, those are not now able to be reviewed. So, in summary, and of course, this appeal starts from the permission given by my Lord Justice Moylan, which was in rather vague terms with this.
Well, I think, following on, linked to what the grounds to why he granted permission, one odd thing about this judgment is the judge talks about this being a summary return.
Yes.
I mean, it strikes me it isn't really a summary return case. This was a case where there was a fully fought hearing.
Essentially, it was. It was a process which took 10 months to get to the point at which the final judgment was made, the application having been made in October 2022. It was not a summary return in that context. There was a full fact-finding, there was a full welfare consideration, and the court...
So it didn't... Lady Hale talked about there being the option of a swift, swift and unsentimental, swift and unsentimental return, or whatever the phrase is.
That did not happen.
It wasn't that, was it? It was a fully fledged, fully fought welfare hearing.
Yes, and at the conclusion of that, the judge gave a very detailed welfare consideration, and of course you have the welfare checklist set out in detail within the body of his judgment, and he identified all those issues which we say were relevant, proportionate, and he exercised his discretion in the proper way, having heard all the evidence, having determined the facts, and having an eye to the best interest of these children. So, ladies, my lord, unless there's anything further I can specifically assist you with, those are my submissions in reply.
Thank you very much, Mr. Jarman. Given the time, I think we'll recommence at 1:55.
Can I just say that?
Yes. Sorry.
Do you have any instructions on contact?
To reply, my lord.
It's on contact. I'm not asking.
I do, my lord, yes.
Okay. I mean, it would be, in the circumstances,
It's
for
very
my part, I would hope that over the shorter German you would be able to get instructions.
Yeah, I have some
Right,
instructions
for,
already.
for there to be substantial and significant contact
Yes.
to the father over the Christmas period.
My lord, there's
I mean, I don't want to.
Yeah.
I just said, because that's something for my part. I will be interested
Yeah.
to hear what you have to say after.
Yes, yes. In that case, I'll wait for after hearing.
Thank you. 5 to 2.
Thank you.